K-Law Academy. We will study administrative procedures in litigation in Korea in this session. What are administrative procedures? In a broad sense, the administrative procedure corresponds to the legislative or judicial procedure and refers to any procedure that is required to engage in administrative action or an exercise of administrative authority. The administrative procedure, in a narrow sense, refers to a process of negotiation with external legal or natural persons that is required when an administrative agency makes any decision regarding administration by exercising its authority. It can also be defined as a procedure in which the citizens participate in the process of administrative decision-making. It can be understood as an ex-ante decision-making procedure, as compared to an ex-post remedial procedure. As such, administrative procedures provide citizens with opportunities to protect their rights and interests. Shall we take a closer look at administrative procedures and litigation in Korea? Understanding the Administrative Procedures Act. Article 12 of the Constitution of the Republic of Korea prescribes the due process of law, which undoubtedly applies to administrative procedures. However, the Administrative Procedure-related bill was only enacted at the end of 1996 after many difficulties. Let's take a closer look at the Administrative Procedures Act. The Administrative Procedures Act is a general and basic law in relation to administrative procedures and consists of 8 chapters in total. Chapter 2, which prescribes procedures for individual administrative dispositions, consists of the greatest number of provisions. In this video, we will briefly review the main contents of Chapters 1 and 2. Chapter 1, which deals with the general provisions of the Administrative Procedure Act, defines the terms within this Act and sets out the scope of application of the Act. The definitions of administrative agency, disposition, party, etc., appearing in the Administrative Procedures Act are as follows. In particular, in subparagraph 4, party and party, etc., are defined separately. In the Administrative Procedures Act, party and party, etc., are defined and applied separately in accordance with the nature of individual provisions. Article 3 prescribes that the procedures for administrative dispositions, reports, notices of proposed rulemaking, notice of proposed administrative actions, and administrative guidance, hereinafter referred to as administrative procedures, shall be governed by this Act except as otherwise provided in other statutes. The exceptions to the application are as follows. In particular, subparagraph 9 is intended to restrict procedural guarantees set at a lower level than those stipulated in the Administrative Procedures Act, which is a minimum safety measure to prevent infringement of people's basic rights. Articles 4 and 5 of Chapter 1 of the Administrative Procedures Act stipulate the principles of acting in good faith, protection of trust, and transparency, which are the operating principles of administrative procedures as follows. Article 9 stipulates the qualifications of a party, etc., as a person who is qualified as a subject of rights and obligations pursuant to other statutes and regulations, etc., in addition to a natural person and a legally recognized person. Article 10 provides for succession of status of a party, etc. It prescribes comprehensive succession by inheritance or merger, paragraphs 1 and 2. And specific succession, paragraph 4, corresponding to the transfer of rights and interests. As service is a method of notification of an administrative disposition and a requirement for the effectuation of such a disposition, and may become a starting point of the period of filing of appeal litigation under the Administrative Litigation Act. Service is important, especially with regard to an administrative disposition. Service may be made by means of information and communications networks only when the recipient of the service consents to it. In this case, service will take effect upon the arrival of the electronic document to the person to receive the service when it is entered into a computer, etc., designated by the person to receive the service. Chapter 2 of the Administrative Procedures Act deals with disposition. It stipulates all matters related to disposition, such as application for administrative disposition, establishment and publication of the processing period, and prior notice of disposition. In the Administrative Procedures Act, an application for disposition is classified as an act of public law by a private person as an expression of intention under public law for the purpose of receiving a beneficial disposition such as a permission. Article 17 stipulates the principle of documentation that any application for an administrative disposition must be filed in writing, and that, in some cases, it is also possible to file an application in the form of an electronic document. It also stipulates that each administrative agency must post all materials necessary for filing an application or furnish the relevant manual available to the public. Furthermore, it stipulates that the administrative agency must not withhold or refuse the acceptance of such an application when it is received. If there are any defects in the application documents, etc., the administrative agency should request that the applicant make necessary supplements within a reasonable period of time. This provision can be interpreted as intended to ensure public administration fairness, transparency, and reliability, as well as the protection of people's rights. Article 19 prescribes the public announcement of processing periods of advantageous administrative acts, such as authorization, permission, approval, and the likes. When it is difficult to process an application within the announced processing period due to any unavoidable cause, the administrative agency may extend the period only once, and within the span of the processing period for the disposition, and the agency must notify, without delay, the applicant of the grounds for such an extension and the expected deadline for the completion of the processing. However, these provisions do not have binding effect, and the Supreme Court also ruled that the purpose of publicly announcing the processing period is to facilitate the processing of applications. In addition, it prescribes that when an administrative agency renders a disposition that imposes duties on a party or restricts his or her rights or interests, the agency must notify such part of such thing as follows. It stipulates opportunities for hearing the parties' opinions in the form of submissions of opinions, hearings, and public hearings. Among them, submission of opinion is the most basic method, and hearings are often held as well. It is stipulated that in rendering an administrative disposition, an administrative agency must explain the bases and reasons for such disposition to the parties, and must render administrative dispositions in writing, except as otherwise provided in other statutes and regulations. It is also stipulated that in rendering dispositions, administrative agencies shall notify the parties of the right to file administrative appeal, administrative litigation, or other objections and their related procedures, deadlines, and other necessary things. This is designed to provide the counterparty to an administrative disposition with convenience to effectively and promptly file an object or a lawsuit such as appeal litigation. So far, we have briefly reviewed the contents of Chapters 1 and 2 of the Administrative Procedures Act. The future of the Administrative Procedures Act. The Administrative Procedures Act, enacted in 1996 when democracy was taking root in Korean politics, and implemented in 1998, has improved transparency and fairness in the administration and fundamental rights of citizens, thereby strengthening the foundation of democracy and lawful administration. Ultimately, it has contributed significantly to the development of Korea through administrative development. However, there are still cases where administrative procedures are merely formal procedures rather than effective preliminary rights relief procedures for the protection of people's rights. The lack of administrative planning procedures and insufficient procedural control over administrative legislation have also been raised as problems. In the future, the Administrative Procedure Act will need to be continuously supplemented and developed so that it can become a key tool that not only improves administrative efficiency, but also ensures procedural justice. That's all for the Administrative Procedures Act of Korea covered in this session. For more information, please refer to the website of the Korea Legislation Research Institute, K-Law Academy.